Hi guys, welcome back to another video. I hope everyone is all doing well. If you're enjoying the content, please don't forget to subscribe to the channel and hit the bell icon to get instant notifications when a video is published. Please also go ahead and like the videos and share them on your favourite social media platforms. So let's dive in with today's video, which is a reply from the Court of Appeals regarding Whomes Steele and Correy's convictions at the Old Bailey. Let's get started. Reply from Court of Appeal, the Lord Chief Justice. Between the 1st of September 97 and the 20th of January 98, the three applicants stood trial at the Central Criminal Court before Judge Hidden and a jury on the indictment containing 5 counts. Count 1 was laid against all three applicants. It charged them with conspiracy to smuggle cannabis and cannabis resin into this country. All the three applicants were convicted. Counts 2, 3 and 4 were counts of murder, each laid against the applicants Steele and Whomes, but not against the applicant Correy. Each count was laid in relation to a particular victim, Patrick Tate, Anthony Tucker and Craig Rolfe. The death of each victim was charged against both of the applicants Steele and Whomes in separate counts. They were both convicted on each of those counts. The applicant Correy, we repeat, was not involved. Count 5 charged the applicant Steele only with a possession of a shotgun as a prohibited person, he being a prohibited person by virtue of a previous conviction. On that count, the applicant Steele was acquitted. Central to the Crown's case was the evidence of the witness named Darren Nichols. He was, on his own admission, an accomplice in the importation of drugs and a crucial witness on the counts of murder. He was a man with a criminal record, with a demonstrated willingness to lie and a relationship with a corrupt police officer. On these and other grounds, he was a witness who was vulnerable to attack. The prosecution accepted that on the murder counts that they had no case without him. His evidence was clearly central to the Crown's case on counts 1 and 5 also. We summarise the substance of count 1 at the barest possible terms. The case for the prosecution relied on 5 trips from this country to the continent. On the first occasion, so the prosecution alleged, Nichols and the applicants Correy and Steele travelled to Amsterdam and left money with a foreign supplier named Stone. They, however, returned to the United Kingdom on that occasion without any consignment of drugs, perhaps because none were available. The second trip was said to involve a visit to Amsterdam by Nichols and the applicant Correy to collect drugs. These, it is said, were delivered to the applicant Steele at a prearranged meeting place on the coast of Belgium, which he approached from the sea in a reinforced inflatable boat. The case was that the drugs were stowed in the boat and that the applicant Correy left in the boat with the applicant Steele and the drugs. The third trip was said to involve a visit to Amsterdam by Nichols with a friend named Reed, who was not charged as a party to the conspiracy. According to Nichols, he collected the drugs, went to the same prearranged meeting place, and on that occasion returned with Steele in the boat to this country. Reed returned on his own. The evidence of Nichols was that when the boat reached the coast of the country, the drugs were delivered to the applicant Whomes. The fourth trip, again, was described by Nichols. He said that he collected a large sum of money from the applicants Steele and Whomes and others, who included the deceased man, Tate. He and the applicant Correy, according to Nichols, returned to Amsterdam via ferry to the Hook of Holland. They hired a car, collected the drugs and travelled to a prearranged meeting place. Again, according to Nichols, the drugs were delivered to the applicant Steele in his boat, and Nichols' evidence was that on that occasion the applicant Correy returned to the country with the applicant Steele. There was evidence that complaints were made about the quality of the cannabis supplied in this consignment. Some of it was said to be inferior. This was taken up with a supplier in Amsterdam who admitted that some of it was inferior. Also, he asserted that a third of the consignment was also of ordinary quality. The fifth trip was made to Amsterdam, according to Nichols, by him and the applicant Steele, travelling by ferry and train to obtain a refund of the money which they had paid to Stone in Amsterdam, which they eventually did. According to the prosecution, but this was very much in issue, It was suspected that Tate, having received part of this consignment of drugs, had received some which may have been an adequate quality. According to the prosecution, this was one possible source of ill feeling between him and in particular the applicant Steele. Steele, however, also said that there was a threat made to his life by Tate, and there was some suggestion of resentment at the manner in which Tate treated his girlfriend. Those alleged grievances against Tate were advanced by the prosecution as the background to the murders. The 3 victims, who included Tate, were found dead early on the morning of the 7th of December in a Land Rover. They had suffered shotgun wounds inflicted at close range. The Land Rover was parked on a farm track in Essex. The evidence given by Nichols, again very briefly summarised, was to the effect that he had met the applicant Steele at his request and that they had met up with the applicant Whomes. The suggestion was that the victims had been lured to the place where their bodies were found and then shot by the applicants Steele and Whomes, or one or other of them. The Crown's case was that Nichols was not involved in the killing but played a part as driver, although he was not party to the plan to kill. The essence of Count 5 was that the applicant Steele had asked Nichols to get him a gun. Nichols did so. He was engaged in performing electrical work on a house belonging to the applicant Steele. He put the gun in the rafters where it is ultimately found. On this count, as already mentioned, the applicant Steele was acquitted, from which the inference is drawn that the jury were not satisfied with the evidence given by Nichols on that ground. That, in a nutshell, is the background of these applications. The first application that we have heard advanced by Mr. Lederman QC on behalf of the applicant Whomes relates to several different grounds. The first is that the judge wrongly exercised his discretion against severance of count 1 from the other counts on the indictment. Mr. Lederman submits that the importations of cannabis, and in particular the early importations of cannabis, had no connection with the murders which form the substance of counts 2, 3 and 4, that the combination of the counts was prejudicial to his client, and that the trial should be very conveniently have been confined to the murders and, if necessary, to the last 2 trips relating to the cannabis conspiracy. He, however, argues that in particular the first 3 cannabis expeditions had no connections with the murders, and therefore severance should have been ordered. He acknowledges that, when the matter was before the judge, the applicant Steele was strongly of opinion that all the matters relating to the importations of cannabis should be heard together, and accordingly, the suggestion that the last 2 trips alone should form part of the indictment was not a matter which the judge was called upon to consider. Mr. Lederman acknowledges that a decision on severance is very much a matter for the discretion of the trial judge, but nevertheless submits that, in the particular circumstances of the judge's exercise of discretion is open to criticism. In our judgment, the judge's exercise of discretion was not only defensible, but, as the single judge held correct, it would, in our view, have been artificial to invite the jury to hear the murder counts on their own, since it would have appeared to be an entirely motiveless crime, which they would have found it difficult to understand. Mr. Lederman submits that the motive which the prosecution were able to advance was unpersuasive. But whether it was a persuasion motivation or whether or not it was a matter for the jury, it would have been very difficult indeed for the Crown to paint any background to these killings had the conspiracy been tried separately. Equally, had count 1 been severed and tied on its own first, any intelligent jury would be bound to ask how it all ended. Having heard to be in dispute with Tate at the end of the story, the judge would be bound to ask themselves, and tempted to speculate, why no evidence from him had been forthcoming. In our judgment, this formed a single coherent story in the prosecution's case, if the prosecution's case was correct, and it was for the jury to decide whether it was accepted or not. It was, in our judgment, the only intelligent way in which the matter would be put before the jury, and subject to appropriate directions, we feel sure that the judge's decision was correct. An alternative submission is made that, even if the judge was right to make the decision, which he did in the outset of the trial, nevertheless he should have formed a different view later on, Severance is of course a matter that the judge can properly be asked to reconsider. The judge was asked to reconsider it. He formed the same judgment as he originally formed, and we see no reason to think that he was wrong on that occasion either. Thirdly, it is submitted on behalf of this applicant that the judge should have acceded to the defence submission that there was no case for the defendants to answer. It depended on the attack made on the reliability of the witness Nichols in cross-examination. Nichols was in the witness box for several weeks and was cross-examined at very considerable length, with the result that they had an extended opportunity to form a judgment of him. No doubt it is true, and one can have no doubt that there were aspects of his evidence which were severely mauled in cross-examination. Nevertheless, the essential question for the judge was whether, if the jury substantially accepted the thrust of Nichols's evidence, there was a case for the defendants to answer. Having reminded himself of the laid test down in the very familiar case of R versus Galbraith, the judge held that there was a case to answer. We entirely agree that with the judgment, Mr. Lederman has invited us to read the extract which has been transcribed of the cross-examination of Nichols that we have done. It reinforces, in our view, that the judge was right to take the view he did. The next point, advanced on behalf of the applicant, Whomes, concerns a witness named Jasper, who was called by the applicant Steele. He gave an account to the police and in the witness box of an occasion at the end of '95 when he had gone to a place, or very near a place, where the bodies of the 3 deceased victims were found. He was permitted in evidence to describe this journey, to describe how a passenger in his car had left the car, had returned, had a shotgun, and was subsequently dropped off by him. Application was, however, made to the judge to allow the witness Jasper to be questioned as to an alleged admission of having effected the killing carried out by the unnamed and unidentified individual whom he had carried in his car on this occasion. The judge refused to allow that question to be asked. Regarding it as an inadmissible hearsay. Approaching this matter, as we must as one of principle, the first question which we ask is this: the witness testifying in court allowed to give evidence of what a third party said to him out of court in order to prove the truth of that statement? The answer to that question, as a matter of law, is in our judgment, yes, but only in very clearly defined and exceptional circumstances. It was familiar and was very succinctly put by Lord Normand, delivering the advice of the Privy Council in Teeper versus the Queen, 1952, AC 480-486, where he said, "The rule against the admission of hearsay evidence is fundamental. It is not the best evidence and is not delivered on oath. The truthfulness and accuracy of the person whose words are spoken to by another witness cannot be tested by cross-examination, and the light which his demeanour would throw on his testimony is lost." Woodbridge in R versus Blarslands, 1986, AC 4154, having quoted that extract, observed, "The danger against which this fundamental rule provides a safeguard as that untested hearsay evidence will be treated as having a probative force which it does not deserve. There are, however, well-established exceptions to this exclusion of hearsay evidence. One is to be found in the case of defying declarations, which is not relevant to the present case. It is to be found in the rule relating to rescue, an exceptional, very fully and authoritatively liquidated by the evidence of the Privy Council in Ratton versus the Queen, 1972, AC 378, and by the House of Lords in R versus Andrews, 1987, AC 281. This is a rule which permits evidence to be acquidated of a spontaneous identification of an offender made by a victim or by a bystander during or in the immediate aftermath of the commission of a crime in circumstances which preclude the possibility of concoction, ulterior motive or error, and which involves the spontaneous or any identification of an offender, since the witness Jasper was wholly unwilling to name or identify the alleged marker of the statement which was in issue. We note that in R versus Blarsland, 1986, AC 41, which preceded the decision in G. v. Andrews, the first question certified for consideration by the House of Lords was in these terms: whether the confession by a person other than the defendant to the offence which the defendant is charged is admissible in evidence where that person is not called as a witness. Reg versus Turner, Bryan, 1975, 6-1, CR APPR 6-7. On petition to the House of Lords, leave to appeal on that ground was refused. With reference to it, Lord Bridge said, it had been recently pointed out that the refusal of the Appeal Committee of the House of Petition for leave to appeal is not the equivalent of the authoritative decision of the House affirming the decision of the Court of Appeal from which leave to appeal was sought, since leave may be refused for a variety of reasons. See in R.E. Wilson 1985, AC 750-756, per Lord Roskill. However, the decision of the Court of Appeal, Criminal Division, in Reg versus Turner, Bryan, 61, CR APPR 67, which an appeal on the first certified point would call in question, was itself based on the majority decision of the Lordship's House of Myers versus Director of Public Prosecutions, 1965 AC 1001, which established the principle never since challenged that it is for the legislature, not the judiciary, to create new exceptions to the hearsay rule. To admit in criminal trials statements confessing to the crime for which the defendant is being tried, made by third parties not called as witnesses, would be to create a very significant and, many might think, a dangerous new exception. This present case does not, in our judgment, fall anywhere near admissibility under the resciste exception. It is, in a statement made by the alleged assailant, it does not identify the person accused or said to have committed the crime, and there is nothing to suggest that it was made in the immediate aftermath of the killing. It was certainly not made during the killing. In our judgment, the judge was right to exclude evidence of this hearsay statement. Had he thought fit, as we think wrongly, to allow it to be admitted, he would have been bound to advise the jury to place no reliance on it. The next ground, advanced on behalf of this applicant, relates to the evidence which was adduced at the hearing of mobile telephones. It is apparent that at various stages during this story, very active use was made of mobile telephones by various alleged participants. For present purposes, however, the argument turns on a relatively narrow issue, which is where Nichols and the applicant Whomes were on the 6th of December 1995. Shortly before 7 p.m. The evidence showed that Nichols had an orange mobile telephone and the applicant Whomes a Vodafone. The evidence suggested that Whomes made one call which was routed through a call station at Ingatestone and one through a call station at Hockley. Evidence was called for an expert to suggest that if the applicant Whomes had been at Workhouse Lane, where the bodies were found, that it would have been unlikely that the calls would have been so routed. The applicant Whomes himself said that he was at the Wheatsheaf public house, and the expert's view was that this routing of the calls would have been more consistent with this account. So far as Nichols is concerned, he gave evidence that, after dropping the applicant Whomes, he returned to the Wheatsheaf public house, but there found that he was unable to obtain a good signal, and accordingly drove to Meadow Road, where he got a good signal. On this issue also, the expert gave evidence. He suggested, as a result of tests which he carried out, that one would have expected a good signal at the Wheatsheaf and a less good signal at the site to which Nichols said he went. The expert, however, while expressing opinions, as he was fully entitled to do, showed a proper degree of caution and reserve and admitted that nothing could be regarded as certain. A complaint that is made is not that the judge in any way misrepresented the evidence on this point or failed to remind the jury of it, but that he simply reminded the jury of all the evidence on the point without analysing it in order to indicate which points were relied on in particular by the defence. Mr. Effrington QC, who has argued this point on behalf of the applicant Whomes, submits that the jury were entitled to be assisted and that the judge should have reminded the jury what the specific issues were. In our judgment, this suggestion needs to be viewed in context. The judge delivered an extremely long but also extremely fair, comprehensive and neutral account of the evidence, which contained very little indeed by way of comment, while some summings up do recite the evidence and then outline the points which arise. The judge did not at any stage of his summing up adopt that course. We also bear in mind that these points have been the subject of very detailed evidence and argument over an extremely long period. Mr. Etherington submits, and he was echoed also in this by Mr. Gledhill on behalf of the applicant Steele, that the evidence was complex and not easy to assimilate. At first blush, this is no doubt true. But to bear in mind the length of this trial and the degree of obvious care which was devoted to almost every conceivable issue, we think it unlikely in the extreme, having heard both counsel and the judge, that the jury were not very fully alive to where the fairly limited issues were. On this grounds, also, we find no reason to criticise the judge. The last ground advanced on behalf of this applicant is to criticise the verdicts of the jury as irrational. Is that it was irrational of the jury to acquit on count 5 and to convict on the first 4 counts. It is said that the evidence of Nicol was so crucial to all the counts that there was no rational basis upon which the jury could have doubts about count 5 if they had none about the other counts. In our judgment, that is not an acceptable submission or even an arguable one. The evidence on count 5 was quite different. It is plain, as has been pointed out to us, that on certain matters relating to date, Nicol's evidence was undermined in relation to count 5. There was little or nothing to corroborate it. There were documents produced by the applicant Steele which threw doubt about his account. Having been reminded that any doubts should be resolved in favour of the defendant, we infer that on this count the jury did feel doubt. That does not, however, suggest to us that they were in any way irrational or inconsistent in feeling no doubt about the other counts. In relation to the applicant Steele, certain of the grounds advanced are the same. It is again submitted that the judge was wrong to reject an application to sever the drugs counts from the murder counts and to order trial of the counts together. It also said that he was wrong to reject the submission that the counts should be severed on the second occasion when it was made. It is also argued that he was in error in refusing to hold that there was no case on counts 2, 3 and 4 for the jury to consider. On those grounds, we have nothing to add to what we have already said in relation to the first applicant. The same is true of ground 4, which relates to the telephone evidence, and of ground 5, which relates to inconsistency. This applicant has, however, himself drafted a number of grounds which Mr. Gledhill has particularly and sufficiently put before us. First of all, there are 3 grounds relating to the judge's handling of the jury. It being alleged that there was jury intimidation, that there was improper jury vetting, and that the judge should have discharged the jury because of an incident involving a complaint about the way the prison officer was behaving while in charge of the defendants. There is, in our judgment, no substance whether in any of these points. For example, it is submitted that the jury was unbalanced because it did not contain employed persons or youthful persons, because there were too many women, because it did not have professional personnel. It may very well be that the jury consisted of people who could, without gross inconvenience, sacrifice the amount of time to their public duties which this case was called for. However, in our judgment, there is no suggestion that there was a material irregularity or anything which could have jeopardised the safety of the verdicts. It is then argued that these verdicts were inconsistent, but that is a matter by which we have already dealt. There is a complaint that the judge failed to give a proper direction on the burden of proof. But the judge's direction was, as is admitted, in entirely conventional terms. There is no ground for criticising it. There is a complaint that the judge's summing up was materially deficient and substantially unbalanced on crucial defence issues. In any trial of this length, it is doubtless a possibility to identify various matters which the judge has omitted to mention. If they are of substance, they can be brought to the attention of the judge. The trial judge in this case gave counsel an opportunity to raise points with him before the jury were directed to retire to consider their verdicts. Has already indicated, a very long, very comprehensive and very neutral summing up. It was not a speech for the defence, but nor was it a speech for the prosecution. Neither singularly or cumulatively, in our judgment, is this complaint tenable. In ground 7 the applicant suggests that there was a misdirection of fact. This relates to what appears to have been a slip of the tongue by the judge, which can have no effect on the trial. There are other matters which, it is said, the judge should have mentioned, but these seem to us of the most tedious kind. In ground 8, it is argued that the judge wrongfully omitted evidence which was inaccurate in detail and used to corroborate false claims by the prosecution. This relates in the main to schedules of telephone calls which were laid before the jury. It may very well be that there were errors in such schedules. It would indeed be surpassing if there were not. It does not, however, appear in particular, so far as the telephone calls on the day of the alleged murders are concerned, that there was errors which are in any way false, gloss on the case. It is then said in ground 9 that evidence was wrongfully excluded. The applicant complains that a video giving evidence of his marine activity over a number of years was excluded, and that various witnesses who should have been called were not. Of complaints made by the applicant concerning the behaviour and conduct of the case by counsel then instructed. There are a considerable series of complaints. Counsel has chosen some in order to make good of this ground, but has made it plain that none of these points in any way abandoned has been indeed taken us through them in detail. The first of these particular complaints, which he highlighted, was that counsel failed to cross-examine Nichols about an alleged statement made to him to the effect that an earlier shooting of the victim tape prompted Nichols to say, "I could shoot somebody." It is apparent that the applicant Steele was aggravated that this point had not been put to Nichols and took it up with counsel, pointing out that it had originally been contained in a very lengthy statement of his evidence. Counsel was at first of opinion that the matter had been brought to his attention, but on further examination found that it had. According to the counsel's written account, he explains to prosecuting counsel that the failure to put his point, which at this stage is being held against the applicant, was his responsibility. He then says that he raised the matter with the judge, who agreed that he should immediately explain the matter to the jury. This, according to the leading counsel, was done, and the jury were clearly told that his failure to put the point should not in any way reflect upon the applicant Steele. He asserts that the topic was not referred to again by the prosecution or the trial judge, that he himself did refer to it during his final speech in an attempt to dilute the effect upon the judge, and no doubt the jury, of the manner in which the applicant had given evidence. It may very well be that the account of leading counsel is challenged by the applicant. A second matter of which he strongly complains is the late delivery of his alibi. He submits that he gave detailed instructions concerning his whereabouts on the date of the murders in good time to serve an alibi notice within the time limited, but that it was not done, and that this worked to his disadvantage in the trial. His account of this matter is contradicted by Miss Patricia Lynch QC, who has stated that the applicant himself did not wish the alibi notice to be served because he regarded the police as corrupt and thought that the witnesses would be approached or suborned. But then, as it may, no doubt her account of this matter may be challenged, although it appears to be, to some extent at least, corroborated by